In today's episode, we will unveil the truth behind police interactions and delve deep into the complexity of who's involved, what takes place, and the delicate balance of right and wrong. On May 10, 2020, the Suisun City Police Department received a report from North Bay Medical Center regarding an individual who may have consumed nail polish remover. Officer Tiffany Konoma and Officer Cody Marler promptly responded to the call and were dispatched to the home of Sergeant Cyrah Hawkins, a military veteran located in Suisun City, California. Sergeant Hawkins asserts that his rights are being violated by the police, but he fails to provide an explanation. The officers argue that they are not infringing on any rights by standing on his porch. The immediate area surrounding a person's home, including the front porch, is referred to as the curtilage, and the Supreme Court has established that curtilage is protected as part of the home itself under the Fourth Amendment. In the 2013 case of Florida versus Jardines, the Supreme Court emphasized that the home is paramount when it comes to the Fourth Amendment. The core of this amendment is the right of an individual to retreat into their own home and be free from unreasonable intrusion by the government. This right would lose its practical value if law enforcement agents could freely stand on a home's porch or side garden to search for evidence. The right to retreat would be significantly compromised if the police could enter someone's property to observe their activities through the front window. Nevertheless, according to the knock and talk doctrine, officers generally have the authority to enter the curtilage of a home, knock on the door, and ask questions without a warrant. In the Jardines case, the court clarified that knocking on the front door is seen as an invitation or permission to attempt an entry. This implicit permission usually allows the visitor to approach the home through the front path, knock promptly, wait briefly to be received, and then, unless invited to stay longer, depart. Therefore, a police officer without a warrant can approach a home and knock, as any private citizen would do. However, this doctrine does not grant officers the power to bypass the Fourth Amendment's warrant requirements for searches or engage in activities that exceed accepted social norms. As explained in the Jardines case, encountering a visitor at the door is customary, even if occasionally unwelcome. However, discovering the same visitor exploring the front path with a metal detector or bringing a bloodhound into the garden before a proper greeting and permission to enter would likely lead most people to call the police. The scope of a permission is not only limited to a specific area, but also to a particular purpose. Applying this principle, lower courts have ruled that certain police actions surpass the scope of the implied permission to knock on an individual's door without a warrant. In the 2022 case of Cupp versus Smith, the Northern District of California found that an officer exceeded the implied license to knock when he entered the garage area, spoke to the homeowner's worker, took photographs of the garage and its surroundings after walking through the carport. Similarly, in the 2013 case of Powell versus State, the Florida 1st District Court of Appeals held that an unconstitutional search occurred when police officers stepped off the front step of a mobile home and looked into a window that they couldn't see from there. The court clarified that even during lawful knock-and-talks, government agents can go beyond a reasonable visit to the front door or porch by physically encroaching into areas where residents have a reasonable expectation of privacy. However, the court also acknowledged that under certain circumstances, implicit permission may exist to briefly look through an uncurtained window from a front porch to check if the resident is approaching the door, as long as no unreasonable means or devices are used. While it is highly likely that a court would conclude that the officers did not violate Sergeant Hawkins' rights by knocking on the door to ask questions, it is unclear how a court would perceive the officers' actions of walking over to look inside and knock on the front window. Later in this episode, we will discuss the walk and talk doctrine, which would likely lead a court to determine that this did not violate Sergeant Hawkins' Fourth Amendment rights under the exigent circumstances doctrine. After Officer Marler directed a vulgar insult at Sergeant Hawkins, the latter understandably became enraged and reciprocated by directing profanities back at Officer Marler. Although Officer Marler's conduct did not amount to a criminal offense, it unequivocally violated Policy 323 of the Suisun City Police Department, which outlines the expected standards of conduct for officers within the department. The policy explicitly prohibits discourteous, disrespectful, or discriminatory treatment of any member of the public. The use of obscene, indecent, profane, or derogatory language while on duty or in uniform, as well as any other conduct that any member with reasonable knowledge should recognize as unbecoming of a department member, or that reflects unfavorably upon the department or its members, potentially leading to a disciplinary action. Furthermore, it is worth noting, as previously discussed on ATA, that Sergeant Hawkins was well within his rights to express his displeasure with Officer Marler's behavior by utilizing profanities and insults. The Supreme Court, in the 1987 case of City of Houston versus Hill, clarified that the First Amendment protects a significant amount of verbal criticism and challenge directed at police officers. After Officer Konoma asks Officer Marler to step aside, she explains to Sergeant Hawkins that they were dispatched to his residence for a welfare check due to a possible medical emergency, suggesting a mistaken address. A welfare check is a police response to ensure an individual's well-being or safety, unrelated to criminal investigations, but associated with the police's community caretaking function as defined by the Supreme Court in the 1976 case of Cody v. Dombrowski. This function involves police duties divorced from detecting or investigating criminal violations. Although the Cady ruling pertained to vehicles and not homes, subsequent lower courts construed it as establishing a community caretaking exception to the warrant requirement, permitting officers to enter homes without a warrant for non-investigatory purposes, like preventing suicide or conducting welfare checks on unresponsive elderly individuals. However, the Supreme Court clarified in the 2021 case of Caniglia v. Strom that there is no standalone community caretaking exception for homes, and that officers may not enter homes or their surroundings while performing community caretaking functions unless a warrant exception applies. Nonetheless, warrantless entries previously justified under the community caretaking doctrine may still find jurisdiction under the exigent circumstances doctrine. Justice Kavanaugh, in his concurring opinion, explained that this doctrine enables officers to enter a home without a warrant in specific situations, such as combating fires, investigating their causes, preventing the destruction of evidence, pursuing fleeing felons, addressing threats to officer safety or public welfare, providing emergency aid to injured occupants, or protecting occupants facing serious harm. Given that the officers responded to a call regarding a potential medical emergency, it is likely that a court would deem the exigent circumstances doctrine applicable. Consequently, the officers would be justified in looking through windows, or even entering the home if no one responded to the door, without violating the Fourth Amendment. Shortly after Officer Konoma departed from Sergeant Hawkins' residence, Officer Marler returned, knocking on the door and expressing remorse for his prior behavior. Unfortunately, Sergeant Hawkins remained unsatisfied and decided to share the footage he had recorded of the incident on his YouTube channel. In response to the public's outcry, the department released a statement on May 13, 2020, addressing the matter. Over the weekend, one of our Suisun City police officers engaged in an unfortunate encounter with a resident while responding to a service call. During this incident, the officer used inappropriate language that does not meet the standards upheld by the Suisun City Police Department. Both the City of Suisun City and the Suisun City Police Department want to assure our residents that such behavior is unequivocally unacceptable. The statement further quoted Chief Aaron Roth, who stated, "This regrettable incident serves as an opportunity for us to learn and improve as we work alongside our community to make Suisun City a better place for everyone. On behalf of the Suisun City Police Department, I extend a public apology to the individuals involved in this incident and the entire community." Consequently, Officer Marler was relieved of his duties within the department, although it remains unclear whether he was terminated or allowed to resign. Overall, Officer Marler's conduct merits an F grade due to his disrespectful assumptions regarding Sergeant Hawkins' relationship with his wife, his use of profanity and vulgarity toward a citizen, and his complete lack of professionalism throughout the encounter. Despite eventually offering an apology, Officer Marler's behavior from the onset derailed the interaction and hindered the swift identification of the mistaken address. Instead of focusing on locating the correct address for an individual who may have ingested nail polish remover, the officers were forced to allocate precious time to address Sergeant Hawkins' legitimate complaints. Such delays in medical emergencies can have fatal consequences, and this situation could have been easily avoided if Officer Marler had conducted themselves professionally. While there is room for improvement in how Officer Konoma and Officer Marler initiated the interaction, Officer Konoma maintained a professional demeanor throughout, attempted to de-escalate the situation, and remained calm even as Officer Marler and Sergeant Hawkins lost their tempers. However, it would have been helpful if Officer Konoma had explained the reason for their visit as soon as Sergeant Hawkins opened the door, rather than immediately interrogating him, which made him defensive from the start. We hope that Officer Konoma learns from this encounter and enhances her questioning techniques for future welfare checks in similar situations. Similarly, Sergeant Hawkins receives a B, because although his angry response escalated the situation and caused a delay in resolving the interaction, his outrage was understandable, and his expressions of anger were protected by the First Amendment. As Sergeant Hawkins rightfully stated, he was not the one wearing a uniform, and we cannot blame him for standing up against rude and insulting conduct from a police officer. This incident highlights the crucial role that officers play in setting the tone of an encounter, and had Officer Marler refrained from making disrespectful statements from the outset, the situation likely would have been quickly resolved without incident. Thank you for watching our video where we delved into the intricacies of police interactions, sorting out the who and what, and determining what's right and wrong. If you found this content informative and thought-provoking, we kindly ask you to hit the like button and subscribe to our channel.